Okay, good afternoon, everyone. Welcome to this webinar by the King's Chambers cost team. Today, Matthew and I are looking at commencing assessment proceedings, default certificates, and the general principle and drafting point of dispute on the general principle of where does it all go wrong. And so today is essentially about avoiding problems on assessment. We've already had litigation. We want the cost process to go through as smoothly as possible. So it's about serving the bill of costs, default certificates, applications to set aside default certificates, and then drafting points of dispute effectively. And there is a link that I'll get to later between applications to set aside default certificates and Matthew's session on drafting points of dispute effectively. And the rules in relation to the commencement of detailed proceedings, they have to be served on the paying party, and the rules as to what is required is there a copy of the bills, the notice of commencement, and that should be generally be served within 3 months of the event giving rise to the bill of costs. Now, strangely, nowhere else in the rules, if the receiving party doesn't issue the application within time, the rules state the receiving party can make the application, and the court can direct that unless you make the issue the proceeding promptly or within a certain date, you can be disallowed part of your interest and costs. Now, the penalty for serving late is interesting, because if the paying party doesn't make an application and you issue late, the only penalty the court can impose is to disallow interest for a period. It will disallow interest, but it will not impose any other sanction except in accordance with Rule 411, misconduct. So it's quite strange that there's a time period here. The receiving party's got the power to apply to make you serve the commencement proceedings. If you don't and serve late, the only penalty is normally an interest, unless it allows the misconduct, and being late in itself is unlikely to give rise to that kind of sanction. So they are a very simple process. Where do things go wrong? And things go wrong a lot in relation to serving the process. A remarkable number of cases of problems have arisen because of just misservice of the bill of costs of the originating process. And the case called Grekor Fisken, which was a few weeks ago, and it's the case that really gave rise to the webinar today. The master said this: the provisions of the CPL for service upon a solicitor for service by email and for service to the right postal address should be familiar to every solicitor who conducts litigation. And the multiple errors made in purporting to serve the defendant in this case could have been avoided with a little diligence. And one of the main aims today is to just give you the knowledge and to have that kind of little diligence. What happened in that case was the claimant served the bill of costs in circumstances where the defendant's former solicitors were still on the record. They've mentioned the new solicitor had taken over. Those solicitors were not on the record. They served at the inverted commas new solicitor's address. They also served the property owned by the defendant, which didn't qualify as an address for service, never would have done. Also served defendant personally by email. And then when their response was received, the claimant entered a default cost certificate. So there's lots and lots of attempts there in relation to service, none of them valid. And as a result, the default certificate was set aside. The court said it wouldn't rectify the errors, it would not validate service, and be wary of all service issues. So in the future, as I said, it just had no sympathy at all with the claimant who's just not bothered to look at the rules or even think about complying with the rules. Because what had happened was the service had been attended by a method not permitted by the rules. That is to say, upon the defendant directly rather than upon his solicitors. So the key points to take away from that is knowing where to serve, ensure that service complies with the rules, and if in doubt, ask. It's a simple matter to ask, where do you want service to take place? Often it's quite obvious when the defendant solicitors or the other paying parties solicitors are still on record, but it's an important point to clarify, because you can see in that case they took a lot of steps, served a lot of people, and the one thing they managed not to do was serve on the person who should have been served under the rules. The other interesting case is Serbian Orthodox Church, where again service took place at an old rung address. The notice of commencement was sent to the old email address. That old address was set up to instantaneously forward email to the new address, so it was there within less than a second. And the court held this was not good service. It wasn't valid as service. You should have checked and known what the new address was for service. The solicitors said they would accept for service by email, but you served it in the wrong address. But the High Court retrospectively validated service and then refused, and we'll look at it later, the paying party certificate for relief from sanctions to set aside the default certificate. I'll look at that in more detail later on. Well, that's actually quite rare for the court to validate service. It's going to be that unusual. It did happen in the case we looked at earlier, but in the case here where there was just no where there's just no attempt, then there is you're going to have major problems getting service effected. Now, if you've got valid service, you have a valid default certificate, and that is important. If you've got invalid service, then the default certificate is going to be set aside as a right, unless you can persuade the court to rectify the matter. If you have valid service, the burden on the paying party to set the default certificate aside. What happens if you've got two paying parties and you don't serve on one of them? That's a mistake made in the case of Mannering and Goldtech Investments. It's quite important here you get the correct case. It's number 2. There are a lot of cases, or several cases involved in this case, but number 2 is the important case. Two claimants were liable to pay costs to the defendant. The defendant served one claimant, not the other. Went through a horrendously long and detailed, I think, process. But went through assessment, and the Court of Appeal held that the bill wasn't valid against the claimant who wasn't served, and as a result, it couldn't be valid against the party that was served. Had no sympathy at all with the receiving party. Those who ignore the time limits which were prescribed by the rules and which are designed to achieve the convenient disposal of proceedings within a reasonable time do so at their peril. So again, we have the circumstances of not being properly served, not serving one of the parties, and the receiving party coming to grief. Well, okay, we got to the point of dispute. Matthew's going to deal with the details of the point of dispute. What happens if you don't serve them? You can apply for your default certificate, and but the key point here is 4793. As in default judgment, if you apply for a default certificate, and in the meantime the other party serves the point of dispute, you cannot enter point 5 here. 5 here. If point 5 here, if you serve point of disputes before you get your default cost certificate, the court cannot issue the default cost certificate. You've got your default cost certificate. Well, how do we go to setting aside a default cost certificate? It's not something that should ever be taken for granted. Take a default cost certificate very seriously, because as we've seen, even if you've been misserved, the court can, as happened in the Serbian church case, the court can say, yeah, but we're going to validly retrospectively make that valid service. So now you go and prove that we should set aside the default cost certificate. Now that service is valid. So you've got to even then engage the court's discretion. There are a couple of points, fundamental points. First, and fundamentally, have points drafted and serve these promptly. Now, setting aside a default cost certificate is subject to Denton principles, and they are, as you can see, we'll see later on, applied very, very strictly. Look at what the practice direction says. First of all, an application for an order to set aside or vary default cost certificate must be supported by evidence. You've got to have evidence to support a witness statement which explains that and explains the reason you have failed to serve your points of dispute in time. You've got to make the application promptly, and that word promptly is very important. There are lots and lots of cases in relation to default judgments where the court said you may have a good argument on the merits, but we are not going to set it aside it because you did not make the application promptly. You've then got show a good reason for the court to set aside the default cost certificate, and you've got to, and this is in the practice direction, have a draft of the points of dispute the applicant proposes to serve if the application is granted. So a good reason and the draft points of dispute, and we'll look at later on about the significance of not serving that. And then even if the court is minded to set aside a default certificate, it can say, well, you pay everything, pay the cost claimed to the receiving party in the interim. The court can impose conditions. Now, the other case that led to the webinar being in its current form today is the decision of the High Court Master in the Bank of New York case. There, the Master said this: I haven't got points of dispute. You give me some vague idea of what your arguments are about, but that's far from enough. So what happened in that case was the notice of commencement was served on the 15th of December 2021. It must be 2020. Sorry, I got the wrong but right there. But no points of dispute were served, and you get a default cost certificate for $3 million. And the defendant wrote in robust terms saying the default certificate should be set aside. And it's quite common, we see this all the time. Someone's at fault, you've done something you can under the rules, and the defendant writes to you very nastily and saying, you've got to set this aside, you're a nasty person, when they're the one in default. It obviously didn't help, didn't assist the master in that case. So the master was then considering whether or not, despite the defendant's robust letters, the claimant didn't agree, whether or not they should grant relief from sanctions, essentially. First of all, failure to file the point of dispute is going to be a serious breach. So the first dash of Denton's there. Oversight's not a good reason, and that's normally the reason. Simply an oversight which cannot be a good reason. So you're already 2 down in relation to the Denton test when you're applying to set aside a default certificate. And the court is not going to be a rubber stamp when you're applying to set aside a default cost certificate. Engagement with the court process is required to demonstrate that further court resources should be available in the future. A bill of this size would require probably 2 or 3 weeks of court time to assess. And that issue of the way you're going to do points of dispute is something I'll return to right at the end of my part of the presentation. The master had concerns about being prompt. Having been alerted to the existence of the certificate, promptness is then required. It's actually specifically mentioned. And then a paying party has 21 days to prepare points of dispute. And therefore, the period of time, which started on the 6th of January 21, would have elapsed before the cost lawyers had received the full papers. And I would have expected the cost lawyers to be increased in speed rather than decreased. Here we have the case where the bill and the draft points of dispute to hand were not available when the application was there. It wasn't even there at the hearing. And the master said this: the paying party has already been found liable to pay costs. In my view, the need for points of dispute in some shape or form is fundamental for the prospects of setting aside the default cost certificate in those cases. The paying party in detailed assessment proceedings have already been found to be liable for the receiving party, and therefore there's a very high burden on the party seeking to set aside. In the absence of points of dispute, setting out fundamental or quantum challenges, basically I'm working blind. And relying on general submissions that these costs are too high is not enough. It's just not enough in relation to, I think they had leading counsel arguing it's not enough. There should be meaningful points of dispute. If that couldn't be drafted in time, there should have been a witness statement or some other document produced, giving indication of the nature of the points he was expecting to take. And his view was that in the starting parties have failed to act with sufficient promptness as to be able to set out any case in the detail expected in the hearing of such applications, and such actions do not weigh sufficiently in the balance to grant relief in the circumstances. So there is a $3 million default cost certificate, and the paying party has not got the chance at all now to challenge that. Similarly, in the Serbian church case we looked at earlier, there's a problem over service. There was mis-service, which the court rectified, but there was significant default in the filing of in the paying party responding. There was no good reason for not acting in time. The double negative there, but relief from sanctions was refused. And one thing that worried the master there was that there was a failure to be candid, as you could have been, and that was not in isolation, but against the background of the prior criticisms made of the case in general. And that's one of the points about applying to set-aside default certificates. Under the Denton test, the court could look at prior issues of default. And here, it was looking at prior issues of default, procedural issues, before the cost assessment process. And it was the argument, well, this is a new set of proceedings, rejected. Now I can look at the totality of the case, and if there'd been a history of procedural defaults in the primary action, which led to the cost being incurred in the first place, or the cost order being made, I can look at that, says the, or the court can look at that, says the judge, and it can be a factor in whether or not to grant relief for sanctions in relation to the default cost certificate. And another example, Maston and London Britannia Hotel, we have a default cost certificate that they actually asked for and got time, did the paying party, still missed the time. Default certificate, the sum of £3,633. There were then problems with making the wrong application, but eventually a valid application was made in August. Again, we have there were arguments. Well, we've got an argument. We can knock down the bill, and I've got reasons to have the bill reduced. What the paying party should have done, says the High Court, says the master in that case, was if you can't prepare your points of dispute in time and they won't agree it, you make a prospective application for an extension of time. We're in a totally different world then in relation to prospective applications as opposed to retrospective applications. I'm not going to do that in detail here, but the fundamental point is here is making it before the extension period expired would have paid part to any argument about relief from sanction. A prospective application, the court's not concerned with any of the Denton criteria. It's just concerned with the prejudice that might be caused to the other party by granting the extension of time, and that is usually very little. I'd say 95 to 99% of prospective applications made properly are likely to continue. A much lower percentage of retrospective applications to set aside a default cost certificate. So they went on in that case. I appreciate that refusal to set aside would almost certainly result in the claimant recovering more than would have been the case had there been a detailed assessment, but that's not decisive. There's been a failure to serve the point of dispute within the agreed period. The loss of the opportunity to challenge the bill is a result of negligence, and you've got to live with the consequence of your own negligence. Look at that. There are cases in which the application of the overriding objective and the balance of fairness require that the consequence of negligence must be borne by the negligent party This is one of them. And that problem, that failure, goes a long way. An older case of Kavuma and Hunt, default cost certificate. We had a case where the paying party obtained a 2-month extension for points of dispute, failed to do it then. There were no good reasons, the judge for delay. The other earlier procedural failings in the action were taken into account, and the application was refused. So there is a whole major problem area in relation to setting aside default certificates in these circumstances. You shouldn't be taken for granted. You've got to be prompt. You've got to have point of dispute, and you've got to have that issue. And it was actually the issue which links Matthew and I together this afternoon. You have a default cost certificate against you. You've got to do points of dispute very carefully. And you've got to do meaningful points of dispute. And you've got to assume that the merits of the points you're making were considered in some detail. So, for instance, we had the case where the master said, this is going to take 2 or 3 weeks of court time. Just think if you'd done a point of dispute in support of that, and you'd said, we've only got 10 points you want to dispute. Bum, 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 bum. And that should take a day or 2 at most. And the master can say, yes, these are meaningful. And I can take this, and they are good points, and I'm going to give you permission to run those. It's probably far wiser than the normal, I call incantations you see in points of dispute, where everything is disputed, and the normal points, every point about hourly rates, and then we have the point about the indemnity principle. The first 10, 15, 20 pages of a big bill can be taken basically by sort of cut and paste from the usual points of dispute that people file. So there's a lot to be said, and particularly in these circumstances, for thinking very carefully about the way you draft points of dispute, make them very, very focused, say to the court, these are the points, we've got the good points. Now you might say you might be giving away some money you may feel. I don't think you are in those circumstances, but by having focused points of dispute, you're making it more likely by a fair margin, by a fair percentage, that the court's going to grant you permission to set aside the default cost of it and argue those points. If you have everything including the kitchen sink, then it's going to be far less likely the court's going to give you exercises of discretion to set aside the default certificate. And this is where Mr. Smith, I'm hoping, can come in and show us the best way of drafting points of dispute. I've got a particular recommendation if you're applying to set the default certificate aside, and Matthew's going to extend that more widely. Okay, Matthew, I've stopped sharing the screen, so you should be able to put your...
Excellent. Gordon, can you hear me?
Yes.
Right. Well, while you spoke, there's been a question. Might as well deal with it now before I deal with my part. And the question is this: if issuing Part 8 proceedings, can the court be the first to serve the notice of commencement? My response to that, and you can tell me what you think, my response to that is this: the Part 8 proceedings are simply for the purposes of getting the costs order. Once you've got the costs order as a result of the Part 8 cost proceedings, within 3 months of that costs order, you will then serve the notice of commencement on the paying party, and that does not involve the court at all. The court is not involved in between the parties' detailed assessment proceedings until you request a hearing. Do you agree, or have I got the wrong end of the stick?
I think that's right.
Good. Right. I'll pick up where Gordon left off. And if I can tell you a story that comes with the full authority of a High Court judge, I give that caveat because it's rude. The point Gordon made, and the point that I'm about to make, can be well illustrated by cakes and turds. And forgive me if you've not heard this before. But if somebody gives you a cake and a turd, and your job is to try and get rid of both to the greatest benefit that you possibly can, then what you don't do is you don't put the cake and the turd on the plate together and try and sell them both. You accept the fact that nobody's going to buy a turd off you, so you throw it away and you sell just the cake. That's just the same as just making your best points. And when it comes to points of dispute, I've always viewed it in this way. The objective of points of dispute is similar to the objective of a skeleton argument. It's a piece of advocacy, it's a piece of persuasion. And any judge starting to prepare for a detailed assessment is going to be grateful to you to be steered in the right direction by something that, first of all, is readable. Maybe he drank too much last night, maybe he didn't have enough sleep, maybe he's not interested in the case, but if it's readable, you've got a chance. So your points need to be as short as possible. They need to be in the simplest possible language. And to take Gordon's point, they need to be specific to the case, because overall, your aim is to be as clear as possible. Now, all of that is common sense. And in my view, you could stop there. But the rules are with you. And you all know what those are. CPR 47.9 points you in the direction of the practice direction. And paragraph 8.2 of the practice direction to CPR 47 says, as we all know it, points of dispute must be short and to the point. They must follow precedent G so far as practicable. They must identify any general points or matters of principle which require decision before the individual items are addressed. And they must identify specific points stating, and this is important, stating concisely the nature and grounds of dispute. In other words, not chapter and verse, but the nature and grounds of dispute. Once a point's been made, it shouldn't be repeated, but the item numbers should be inserted in the left-hand box. And don't ignore paragraph 8.3, because there is a method here that certainly in my view is tremendously important. Paragraph 8.3 of the practice direction is the paragraph that deals with the open offer that must accompany the points of dispute. Just by way of a note, but it's an important note, that paragraph ends by saying the paying party may also make an offer under part 36. I would add, and you jolly well should, if and where at all possible, because the analysis that you perform in arriving at the right offer to make will also help you prepare proper points of dispute. So far as precedent G is concerned, well, we all know what it looks like, and I will bring a copy of it, hopefully, up if I can. Let me just open it on my screen, and then I'll share the screen. Right, now. And I want to share screen 3. Hopefully you can see this. You will see, and it's breathtaking, just how succinct it is. Other than the left-hand column, it doesn't mention item numbers. So starting with general point 1, and it's a simple bill, but rates are excessive. Then point 3, the number of conferences with counsel are excessive. No need for 2 fee earners. Timed attendance is on the claimant, excessive, reduced to 4 hours. And then documents, this is wonderful because it just shows that what you prepare has to be readable. And those people who say that you have to do points of dispute line by line, I simply don't agree. The total claim for work done on documents by the assistant solicitor is excessive. A reasonable allowance in respect of documents concerning court and counsel is 8 hours. For documents concerning witnesses and the expert witnesses, 6.5 hours. For work done on arithmetic, 2.25 hours, and other documents, 5.5, reduced to 22.25 hours. Well, I don't think that should be controversial, and nor is this a model that has to be followed. There's nothing to prevent you doing it item by item at all. But that is your model, And for the paying party, you shouldn't forget that, because that document is readable. But as you know, this isn't a model that fits well with the electronic bill. This is prefaced on the basis of a paper bill. But it doesn't take a genius to adapt that model to fit to an electronic bill, and we've all done it. And you will also know that if there hasn't been a costs management order, then your electronic bill may not be phased. Not everybody automatically imports everything from the case management system. So sometimes you'll get an electronic bill where there's been no costs management order, and it is impossible to search by budgetary phase or by task. And really, your only choice is to do a word search in the narrative. And there's nothing wrong with that. The receiving party hasn't done anything wrong, because you will know, again, from Practice Direction 47, and if you want the paragraph numbers, you can look at paragraph 5.2. You can look at paragraph 5.8 at subparagraphs 8 and 9. It's very clear that you don't have to provide either a precedent queue or a detail of the costs claimed for each phase of the proceedings where there's been no costs management order. So what you can be left with is an electronic bill where it can be hard to get a handle on how much time has been spent on different tasks. If you're working only from the narrative column, word searches can be clumsy, because take, for example, work on a witness statement. The narrative might say work on WS, or work on statement, or work on S/ment, or work on evidence, or work on proof. You've got a number of choices. You can either do a number of sweeps of the narrative using a different word every time. Exall has a function where you can do a search for alternatives, but it's worth learning more and more about Exall. I don't profess to be particularly proficient at all, but there was one very large document schedule I had once, and learning how to do wildcard searches can be very valuable. I'll share the screen again, and I'll show you what I mean. Let me just bring up a spreadsheet I had. And before anybody worries, this isn't what I'm about to show you is not a real bill. But hopefully you will now be able to see what looks like an electronic bill. And you'll see column E is just a description of all the elements of work. If I scroll down, and you'll see that there are 200 and odd entries on this fictitious bill, down to 293. All you need to do is insert a new tab. You see down here, I've got sheet 1. And then in sheet 1, all I've done is I've taken the column title, description of work. If you click back, you'll see under the column title, description of work. And then under description of work, in cells underneath, with an asterisk before and an asterisk after, you just put the words in that you want to search for. And here, just for the sake of being random, I've put in witness, interest, and CV. And I can now search. Having done that, I can now go back to tab 14, and I can search column E by any of those words. And I do so by clicking on routine call to expert. I go to the top entry. Long call with client discussing circumstances of claim. Click on that, go to advanced filtering. It opens up, it automatically selects the range, the list range, and then in your criteria range, for advanced filter, you just need to go to sheet 1. This is the table that I prepared. Select everything, including the column title. So those 4 lines, select them, press return, you'll get your dialog box up, click OK, and now you can see it's done a search. And every one of these entries now has one of those words in: interest, witness, CVs, witness, and you'll see there aren't very many entries. So that's a good way of learning. I'm not suggesting that you should take that in the course of this seminar, but it shows you that if you learn a little bit about Excel, an e-bill can be very manipulable, and it's an analysis that will help you in your preparation of the points of dispute. Now, that takes me on to Ainsworth, because how much detail do you need to give? Well, for a long time now, parties in litigation, including in cost litigation, have been expected to give advance notice of what their position will be. That's always been the purpose of pleadings, and that purpose has been taken further with the use of witness statements and skeleton arguments, and as I said before, points of dispute, in my view, plainly serve the same purpose. But there is a huge difference between setting out your argument in such granular detail that it goes on and on and on the one hand, and yet on the other hand, setting out succinctly in a way that will keep the judge engaged what it is you challenge and why. Some receiving parties, and it may just be the devilment of litigation, but some receiving parties in between the parties' assessments argue as if they're entitled to know every word of objection that you will mouth at the hearing. It can't be right to take that approach. It cannot be that points of dispute have to be a script from which there can be no deviation at an oral hearing. In my view, that would completely undermine the purpose and distinction between a pleading and an oral hearing. But there are judges who will listen to an argument that Ainsworth, which as we all know was a solicitor-known client case, applies between the parties. And in my view, that argument depends on a misreading, an understandable misreading of Ainsworth. And you may well have had this argument thrown at you in the course of detailed assessment hearings. Some people will seek to argue that there is no difference in terms of the detail that's needed in a between the parties assessment points of dispute and a solicitor and own client points of dispute. And where it comes from is paragraph 14 of the judgment of Lady Justice Asplin in Ainsworth. And hopefully you can see paragraph 14 there. At paragraph 14, Lady Justice Asplin referred to the judge who said, you don't comply with the practice direction at paragraph 8.2 simply by adopting precedent G. You've got more than that. You've got an obligation to further the overriding objective. And then she carried on. It's possible to understand why costs judges adopt a benign approach to the content of points of dispute in an inter-parties costs assessment where the burden of proof is effectively on the receiving party and the paying party doesn't have access to the solicitor's files. Now, up to this point, it looks like she's saying there is a distinction. She is indeed saying there's a distinction, but that's not what some people say. Some people argue that what follows now suggests that there's no distinction to be made, because she carries on. But even if the Chief Master might have approached the matter in that way, it doesn't lead to the conclusion, amongst other things, that Mr. Ainsworth is relieved from furthering the overriding objective. The case is not distinguishable on the basis that the assessment was to be conducted on the indemnity basis and Mr. Ainsworth had access to Stuart Law's files and that the Chief Master's decision was wrong. Now, my intonation there was deliberate. But the way that reads, you could, if you misread it, you could misread that to come to the conclusion that you can't distinguish a solicitor-known client assessment from a between the parties assessment. And you need to understand that what the judge is doing here is she is paraphrasing His Honour Judge Klein below. Look again at what she says. Even if the Chief Master might have approached the matter in that way, in other words, the more benign way, it doesn't lead to the conclusion, amongst other things, that Mr. Ainsworth is relieved from furthering the overriding objective. And then insert what this grammatically does mean. It doesn't mean the case is not distinguishable on the basis that the assessment was to be conducted on the indemnity basis, and Mr. Ainsworth had access to Stuart Law's files. In other words, it is distinguishable because it's the indemnity basis, so the burden lies on Mr. Ainsworth. He's got to persuade the judge that the costs are not reasonable, and he's had the good fortune to be able to inspect the file, so he ought to be expected to be able to say what he objects to. That's what the judge is saying here. And you can get confirmation of that by looking at what His Honour Judge Klein said here at paragraphs 44 to 46. And you'll see it here, because this is His Honour Judge Klein's judgment now. I've got it from Westlaw. It's not that easy to find. If anybody wants it, then please contact me and I'll send you a copy. But at paragraph 45, there was the argument by Josh Munro on behalf of Mr. Ainsworth. Cost judges frequently adopt a benign approach in between the parties' assessments. And then this is what His Honour Judge Klein said, which is consistent with the way I say you should read Ainsworth. Even if the master might have approached the case in that way, it does not follow that this case is not distinguishable because the assessment was to be conducted on the indemnity basis and the claimant had access to the defendant's file. So it doesn't follow it's not distinguishable. And the reason it doesn't follow it's not distinguishable is because it's different. It's different because it's the indemnity basis and the claimants had access to the file. So there is a world of difference, in my view, with good reason for drawing a distinction between standard basis between the parties' assessments, indemnity basis between the parties' assessments, and solicitor and own client assessments that are not only an indemnity basis, but it's an indemnity basis that is strengthened by the CPR 46.9 presumptions. Now, to prove that I'm right, if you then go to paragraphs 36 to 40 of Lady Justice Asplin's decision, she then lays bare the distinction. And at paragraph 39, she says, in the case of a solicitor and own client assessment, in order to specify the nature, remember these words from the practice direction, the nature and grounds of the dispute, it's necessary to formulate specific points by reference to the presumptions in CPR 46.93. Well, you wouldn't do that in a between the parties assessment because those presumptions don't apply between the parties. They only apply to solicitor and own client. So that, in my view, is a very good reason for showing that the two just aren't the same. And at paragraph 40, you've got to remember that what the Court of Appeal was doing was it was using precedent G as a model, only to follow as far as practicable. But it's only an example, and it's premised upon a party and party detailed assessment in which the paying party won't have had sight of the documentation, and the presumptions in CPR 46.93 don't apply. So there's the difference in the approaches. Now, that takes me on to a way to deal with Ainsworth. And I recommend a mnemonic. And the mnemonic comes from the three words for the reason why Ainsworth and solicitor and own client assessments are different. The mnemonic is presumably the burden is different where there's inspection. And the three words are presumption, burden, and inspection. Now, the burden in a solicitor and own client assessment is created partly by the presumptions at CPR 46.93. And you'll know what those presumptions are. The costs are deemed or presumed to be reasonably incurred if they were incurred with the express or implied approval of the client, and to be reasonable in amount if their amount was expressly or impliedly approved by the client. And of course, as long as the solicitors conducted the work instructed by the client in a fairly ordinary way, those presumptions are going to be satisfied. And then, because it's on the indemnity basis, CPR 44.3.3 applies, and you'll know what that means. Of course, proportionality doesn't apply. And where the amount of costs is to be assessed on the indemnity basis, the resolution of doubt. The court will resolve any doubt it may have as to whether the costs were reasonably incurred or reasonable in amount in favour of the receiving party. So the boot is firmly on the client's or the former client's foot in a solicitor and own client assessment. So he's got the burden. And as you know, in many, many solicitor and client cases, there will be inspection of the file. Now, that is very different to a between the parties assessment on the standard basis, because the burden's the other way round. Proportionality applies. And again, by CPR 44.3, the only costs that will be allowed are the proportionate and reasonable ones. And any doubt as to those two criteria will be resolved in favour of the paying party. So, just how much detail do you go into? Well, take what's happened. With provisional assessment these days, live assessments obviously have got bigger. An electronic bill for about £500,000, say, is likely to be in the region of 3,000 lines long. That wouldn't be remotely unusual for that size of bill. Nobody's telling me that any sensible costs judge wants to invite either a line-by-line challenge or a line-by-line assessment to such a bill. It simply isn't possible in any sensible period of time. And that's to be contrasted with the facts of Ainsworth, because Ainsworth itself was very different, because the client had inspected the period, the particular challenge to documents time that was rejected by Master Gordon Saker was only for a challenge to documents done over a period of 14 days. It was a document schedule claiming 46.8 hours. There were only 32 entries. It was only, what, I don't know how long 32 entries is, but typically a page and a half, maybe. And in the points of dispute, the cost draftsman hadn't even condescended to go into the detail to challenge those 14 days worth of work. Now, it had the rejection of the point of dispute had a greater ramification than that, because one of the things, and I'm not surprised Mr. Ainsworth challenged this bill, but it shouldn't have been difficult for him to challenge. He'd instructed his solicitors for 37 days. After 37 days worth of instruction, they'd billed him over £200,000. So you can understand where the argument comes from. But the document schedule to that bill, the profit costs were £115,000 or thereabouts. The documents schedule, there were 3 of them. And the case of Ainsworth actually only deals with the judgment in relation to 1. But the parties stood or fell by the ruling on the 1 to deal with the 3. And the 3 schedules in total, in other words, all the documents work in that bill, still only came to 12 pages of document schedule. Now, any competent costs representative can do perfectly decent points of dispute on 12 pages. It won't take you so long, and it will be perfectly readable. But in this case, it amounted for £64,000 worth of the £115,000 worth of profit costs. So it would have been time well worth taking. Now, lip service. Gordon said earlier, don't use pat entries into points of dispute. And in my view, that's got to be right. Judges shouldn't be expected to tolerate parties merely taking a punt in the pleadings, either by arguing for very low hourly rates or other unrealistic allowances without giving proper thought to the offers being made, simply in the hope that the judge will see you being very low and the receiving party being very high, and maybe landing somewhere in the middle. And the lower you pitch your offer, maybe the lower the judge will allow. That's not a proper approach to litigation at all. And you've got to understand the position of the judges. They're being presented with large spreadsheets, even larger in lockdown, PDF files of documents, often numbering tens of thousands of pages. Forget the rules. It's simply unrealistic to expect judges to know where to focus their deliberations, where they ought to be thinking about making reductions, if the paying party doesn't make some reasoned effort to explain to the judge where concentration needs to be focused to see where it's said that the claim is excessive. So take some time. Carefully analyze the bill when it comes in. I know we're all under the pressure of time. It's never going to go away. But unless you make the time, you're never going to get this right. That analysis should be twofold. All the time as you're looking at this bill, you're thinking to yourself, where's it going to go on assessment? How much do I need to offer by way of Part 36 in order to protect myself? Now, when you do that, you will see why you object. And if you're making notes at the time, you will know what your points of dispute are. And as we all do, you do points of dispute, and your points of dispute would have offers here that you think are reasonable. You accept that you're not going to succeed on all of your arguments, so your Part 36 offer will be somewhat higher to give you a good level of protection. But there's no room for pro forma wording. You'll simply make the judge's eyes skim over what you've written, and it won't have much impact. So that leads me on to how to deal with various different parts. The bits that we all see repeated, as Gordon said, page after page of nonsense and reference to authority and the stuff that just makes you switch off. Retainer, it's always challenged. If you want the judge to provide some reassurance, which is usually all we do want, that the indemnity principle has not been breached and that the retainer looks to be in order, then you might as well say so in short order, and you can do it in a paragraph. All you need to do is refer to paragraphs 13 and 33 of Dickinson and Rushmer, a case that most of you will know about, and paragraph 23 of Behague, and I think this is the last time I'll share my screen, because Behague is only a first instance case. It's not a citable authority, but tax judge Barbara Mosdale puts it so pithily that it almost ought to be engraved in stone. You can see paragraph 23 of her judgment in Behague. A client engagement letter, sorry, let me share it. I didn't press share. A client engagement letter normally sets out the terms on which a solicitor will act. It's a contract between the client and solicitor. The solicitor cannot and does not give legal advice about the contract between himself and his client. Insofar as the client engagement letter, therefore, sets out the terms of the contract, it can't attract legal professional privilege, as the lawyer is not giving advice qua lawyer, he's not giving legal advice at all. Now, I said that wasn't authority, but Mr. Justice Reimer in Dickinson and Rushmer, although with deference to him, he doesn't say it as eloquently as tax judge Barbara Mosdale does. He simply rejects the notion that it's privileged. And of course, his ruling is authoritative. So you run that argument and you say, the retainer is not privileged. If it's going to be relied upon, it must be disclosed. But you also say, in the circumstances of the present assessment, the paying party is prepared to be pragmatic and to accept the reassurances of the court that the indemnity principle hasn't been breached and that the retainer looks in order. It's not a guaranteed winner, but in my experience, most of the judges in the SCCO, at least, will do precisely that. They will look at the retainer, they'll look at it carefully, and they will check that you're not being taken for a ride as the paying party and that the receiving party has properly claimed what is due to him, her, or it. Next, proportionality. It ought to be possible to state your argument on proportionality simply. Either too much time, too much for simple work, too much money spent, making too much heavy weather of something that doesn't deserve it. 3 or 4 pages of dispute dealing with the authorities is a waste of time. Analyse the bill, do what the Court of Appeal said in West, analyse the bill by reference to categories of costs. Decide, as you're doing the points of dispute, what are likely candidates for challenging by way of proportionality. And let the judge know in the points of dispute, at the end of this assessment, we are likely to challenge, the paying party is likely to challenge on the grounds of proportionality, attendances on the claimant, work in the category of plan, prepare, draft and review, conferences with counsel, and time spent on the schedule of loss, for argument's sake. The judge will be able to see where you're going and will be very grateful for having had the opportunity to have your forthcoming challenge in mind when assessing those particular categories, because he or she may well make the reduction there and then at the time to save going back. And you won't have lost anything because proportionality can be deployed at the time. Hourly rates, pages. How many pages I read that are just wasted words on dealing with guideline rates, what the guideline rates might become, and what the effect of inflation might or should be, I can't say. Apart from saying that the guideline rates are nothing more than a broad approximation and at the moment old, there's nothing more to say about them. And what's more, the effect of inflation can't safely be reflected by mirroring the increase in consumer prices. You can go into Google if you want, and you can type inflation, and you can type legal services. That will bring up the index on the Office of National Statistics website dealing specifically with legal services. And you can work out what the inflation rate is for legal services. That's not a safe tool. If solicitors are simply upping their prices in line with consumer prices, it doesn't make the increase reasonable. Solicitors are not telling the courts what their overheads are, and I don't blame them. But what it does mean, and most judges will accept this, what it does mean is that most judges will say that the increase in cost with the passage in time is a far more nuanced exercise than simply applying some sort of index. And in my view, what Master Wayland said, and the way he said it in PLK, namely that nuanced approach, is the right approach. Other judges who simply apply CPI, I don't think have got the right approach, but who am I to say? Next, item by item. Well, to finish off hourly rates, obviously, what I do recommend is, rather than wasting time on inflation, don't waste time on guideline rates. Use the pillars of wisdom. CPR 44.43. Go through each of the factors and be realistic. You're not going to get far on importance. Most litigation is important to most parties. At best, you're likely to say it wasn't of the highest importance. By the same token, when it comes to complexity, it would be a rare solicitor who undersells itself in the narrative to a bill when dealing with complexity. Most narratives would lead you to believe that this was a state trial. But just because a dispute's intractable or high value or involves expert witnesses doesn't make it complicated. If you have properly used your skill to transpose a dispute into something that is focused and clear, it ought to lead to a more efficient use of time as opposed to a scattergun approach warranting hundreds and hundreds of hours in the bill. And you can make that point. Next, and I'm coming to a close, it's 5:02, item by item. There are three things to say here. Firstly, as Gordon said, don't get stuck in the weeds. Just don't bother with the turds. Don't bother with challenges to 6 or 12 minutes. And if you think, well, the pennies make up the pounds, and there are a lot of these, well, if there are enough of them for it to be worth the risk of irritating the judge, put them all together and just deal with them in one fell swoop. Otherwise, just let them drift. They're not going to make a huge heap of difference. And then on the big items, paint a visible picture by reference to readily understandable stuff. The number of witness statements, the length of witness statements, the length of the schedule of loss, the complexity of the schedule of loss, the need to discuss what was in conference. Maybe take some time to look at the experts' reports. You may be able to argue that actually the huge amounts of time spent analysing what the expert has said aren't warranted by the expert's opinion, because the expert's opinion was perfectly plain. And as you go through, because you'll be providing detail, make sure that you total up your offers. Don't have just individual offers. You don't want the judge saying, okay, well, I can see your point of dispute. How much are you offering overall here? You want that in the points of dispute. The judge shouldn't have to ask you. You need to be communicating to the judge that you've looked at the work, you've thought about it, and that you've made an offer that is reasonable and proportionate. When dealing with documents, and this is perhaps the last point I'm going to raise, on documents, this is perhaps your challenge. How do you take, let's say, 900 lines of the 3,000 or 1,500 lines of the 3,000 are on plan, prepare, draft, and review? How do you do that and provide enough detail and yet keep your points of dispute readable? Well, there's a precedent for that. Remember the old paper bill? The old paper bill had a section, work on documents, and you would simply see an entry with a number of hours by a fee earner. All of the detail was shipped off, of course, to the document schedule. We all know that. Well, why can't you do exactly the same for points of dispute? Keep your points of dispute very readable. You've spent massive amount of time. As far as I can see, you've spent 25 hours on one 4-page witness statement. You've spent 4 weeks on one schedule of loss, totaling £2 million, when everybody knows they don't take that long. Big points like that in your points of dispute. And then you can say, P.S., we have marked, in whatever way suits what you have in front of you, the detail of what we have, and it's in an appendix. We've marked to provide the detail to prove that we've thought about what we say with either a key or with a bespoken reference. You'll have all seen them. Clinical negligence cases, the paying party often has an appendix to the points of dispute. But you'll be able to do that because you'll be thinking about that detail. You'll need to think about that detail simply for the purposes of working out what your Part 36 offer is. Hopefully then, and if you're in Gordon's position with a default cost certificate, you put under the nose of the judge the points of dispute, which the judge can read and understand very easily. And then anybody else who wants to know the detail can look at the appendix. That also will help you to prepare. Well, I hope that's sufficient. Our hour is up. I can see there are 10 questions. I suspect Gordon's going to rejoin me now. Gordon, I don't know whether you've had any chance to look at any of these questions, but before we deal with the questions, was there anything that I said that you violently disagree with, or that you think that needs to be explained further?
No, all the questions are addressed to you, fortunately, and they are all about really the detail needed in points of disputes. That both those questions there's also some on the chat. They're all really there's all the questions about the detail of points of dispute. I suspect most have been answered as you go through. There's one question from Jamie Bedford, which was about the court requesting the court judge to peruse the claimant's retainer. Would it be useful to refer the court to the requirement of PD 47 for the claimant to file the retainer when filing the N258, and therefore the rule makers clearly consider it to be important? I don't know if that's a question or an observation, no.
You can do, but actually, my view is that most judges will do that automatically. They in my experience, part of the reason they don't trouble themselves with the way I run it, and I haven't yet had a judge say to me, I'm not going to look at the retainer. The reason most of them do it, I think, is because when they are preparing, it's one of the first things they look at anyway. So I don't think they need to be told that it needs to be filed. They'll look for it. If it's not there, they'll ask where it is. But it certainly does no harm to include it. If issuing, right, what sanction applies if no offer is made? I think it's right. Most courts do appear to ignore it. But then again, most parties abuse the idea of the open offer. I don't think it serves much of a purpose, quite frankly. I think Part 36 is far more valuable. Somebody's just asked for the effect of Ainsworth and Stewart's in terms of POD's contents. Well, again, my view is that you strongly need to remember, and it's got to be a value judgment. You can't, one size will definitely not fit all, and I'm not sitting on the fence there. But the way I treat points of dispute is in a between the parties assessment on the standard basis where you have the benefit of the doubt on reasonableness and proportionality. I treat it as a skeleton argument, in other words, a précis. I treat it as a piece of advocacy, so it's got to be short and reasonable, short and readable. And the two questions are, what do you challenge and why? And there isn't just one way of doing that. What you can say is the document's time is too much. And you can maybe, and this is often the way I do it orally in a hearing, you pick out the highlights. But to put people's mind at rest, and you'll do this for the offers, and I'm just repeating what I said earlier, it's not going to take you long to go through each item and just mark an item with an X if it's excessive. And you will get receiving parties who say, oh yeah, but we need to understand why you say it's excessive. Nonsense, quite frankly. If the court goes that far, we will be doomed. And I don't expect it ever will in a between the parties assessment. And I've even had one costs judge say to me, really, if you take Ainsworth too far, you need to be careful what you wish for, because assessments, rather than taking 3 days, will be taking 3 weeks. I don't think that the cost bench will allow that to happen. Should points of dispute not at least say, for example, which of the attendances on the claimant are disputed, rather than global reductions? Well, quite frankly, if you can do it, yes, I think they should. But you will see some bills where the attendances on the claimant are so numerous that you've got to find some condensed way of doing it. So it might just be by reference to the item numbers with one compendious objection. For example, these 10 entries were all to do with the witness statement. The witness statement wasn't that complicated. Those 10 entries shouldn't have taken place as they did. What's your view in relation to the extent of the detail required for POD when you have the bill being provisionally assessed? Quite frankly, my view is, I know you're between a rock and a hard place, because that's the only document the judge has got. And if the judge isn't a costs expert, then you might be all at sea. Well, quite frankly, we deserve better than that. And if you get a judge like that, then my view is you'll be gambling. But my view is your better gamble is a short, succinct points of dispute. Take that gamble. And if you've been let down by the judiciary by not being given a judge who's been properly trained on costs, ask for an oral review. I know that's not satisfactory. It's not perfect, but it's the best answer that I can come up with to that situation. In another seminar I attended, someone said the document should be detailed and then on the day of the trial be short and sweet with your points then. That was due to a number of facts like remote hearings being very draining. How would this principle work in a cost hearing like this? Well, that's a perfectly fair point. Where I differ is I think you need to keep the points readable. So the detail should be shoved off to an appendix in just the same way that the document schedule used to be an appendix to the bill, so that you could read through the bill and at least not lose the will to live. Pods being concise, how about provisional assessments? Well, we've dealt with that. What about paragraph 38 of Ainsworth? I'll come on to that in a moment. Same refined approach in respect of, right, okay. So the one remaining question is paragraph 38 of Ainsworth. And that says this. I'll share my screen. I've got paragraph 38 here. Screen, is that screen 3? I think, yeah. That's right. Okay. Let's bring it up again. Paragraph 38. Common sense dictates that the points of dispute must be drafted in a way which enables the parties and the court to determine precisely what is in dispute and why. Well, if the question means that you have to identify each and every line as to whether or not it's disputed, I disagree. Because there might be 50 lines that deal with preparation of a witness statement, for example. It is enough simply to put one challenge in. And of course, what the Court of Appeal says is, all you do is you put your item numbers in the left-hand box. So it's not difficult at all to say succinctly precisely what you dispute and why you dispute it. And of course, bringing up those item numbers, the way that you filter an electronic bill, is not such a difficult thing to do. It can be more difficult simply to filter and get the requisite items up if the person who's drawn the bill doesn't use phases and tasks. But if they've used phases and tasks, it's perfectly straightforward to do. And if they haven't, and if it's a big enough bill, it's not likely to happen if it's a big bill. But if it's a big enough bill, you can always ask them. It'll cost you, but it might be worth it in the long run. That's the very purpose of such a document, I agree. It's necessary in order to enable the receiving party, the solicitor in the case, to be able to reply to the complaints. It's also necessary in order to enable the court to deal with the issues raised in a manner which is fair, just, and proportionately. Of course, that's right, depending on how you interpret it. Because you might, as I say, going back to those 50 lines for the witness statement, you know exactly what's being said of your bill, if you're the receiving party, when somebody says to you, you've got 50 hours on your witness statement here, that's too much. It's 4 pages long. It says you had a terrible accident and you'll never recover. It doesn't take that long to prepare such a document. So to the extent that it might be thought that paragraph 38 says, in Steve Coogan fashion, line 1, the challenge is this. Line 2, the challenge is this. My view is that nonsense. But anyway, there we are. Right. I think, subject to what Gordon has to say, I think that's it. If anybody has any questions so far as I'm concerned, I'm happy to be contacted by email, and I'll leave the last word to Gordon.
Well, thank you to everyone for coming this afternoon. As I said, we've tried to link the two subjects together. The point of how you draft the points of dispute and the issues in relation to procedural problems. And I make the point again that all the points that all the things that Matthew's been saying are doubly important if you are in the circumstances of filing points of dispute and you're trying to persuade a judge to set aside a default certificate. Thank you very much for coming. This is one of a series where we're doing more throughout the rest of the year. And keep your eyes and ears open. We should be able to email you directly. Thank you.